My name is Karas Dungel and student ID is OED8019. Today for the second assignment of business law, I'll be presenting the case of Felthouse versus Bindley, 1862. This case relates to the acceptance of offer by silence, and in this case, I'll be presenting my arguments on the part of the defendant, that is the auctioneer, Mr. Bindley. Now the case summary. My client, the defendant, Mr. Bindley, was an auctioneer. The, the plaintiff, Mr. Paul Felthouse, had offered his nephew to buy a particular horse from his nephew, Mr. John Felthouse. The nephew had previously talked to his uncle regarding the sale of the horse, but the plaintiff did not agree to purchase the horse on the price stated by his nephew. Instead, in a written statement, the plaintiff wrote that he would purchase the horse for £30 15 and would consider the horse to be his if he did not hear more about the same from his nephew. Later on, what happened was the plaintiff's nephew, Mr. John Felthouse, did not reply, and the horse was later sold in the auction. Hence, the plaintiff had sued the auctioneer for conversion. In this case, the defendant, my client, Mr. Bindley, is just an auctioneer, and he mistakenly sold the horse in question during the auction, as because of the pressure of the oak, he forgot the instruction given to him by the nephew not to sell the horse and to keep it in the stock. And later on, my client also wrote a letter to the plaintiff saying that he was sorry for his action and he would try all that was in his hands to get the horse back. However, as Mr. Felthouse has sued my client, the defendant, I'd like to present that though Mr. Felthouse had written a letter to his nephew, but there was no complete bargain at the time of the conversation between the uncle and the nephew. Mr. Felthouse stated in his letter that he would consider the horse to be his own if he heard nothing more from his nephew. But for a contract to be valid, the offer should have been accepted by the nephew. And that is not the case here. And also for a complete contract, for a contract to be a complete one, there is supposed to be a bargain between the person who offers and the person who is to accept that offer. And this is also not the case in this question, as the plaintiff had just written a letter to his nephew stating that he would consider the horse to be his own, but there was no letter of acceptance or no any other communication on the part of the nephew. Therefore, I'd like to present that the plaintiff had no right, or he had no other rights to impose upon his nephew for the sale of his horse for the price stated by him in the letter, until and unless his nephew compiled with the terms and conditions of the letter stated by his uncle in the letter. Therefore, I would also like to say that as there was no acceptance of the offer made by the plaintiff, and also there was lack of bargain between the two parties, the offer remained open until at the day of sale. Though the plaintiff's nephew instructed the auctioneer, my client, Mr. Bindley, not to sell the horse, which he mistakenly did, and to write a letter to the plaintiff later on saying that they would try, or he would try to get back the horse. This letter should not have any legal effect, as it is subsequent correspondence to the offer made by the plaintiff, as there was no acceptance before. And in this case, if the question comes between the plaintiff and the defendant, my client Mr. Bindley, the only question to be considered here is if the horse was the property of the plaintiff at the time of the sale or not. But looking at this case, looking at the scenario, it is clear that nothing was done at the time of the day of auction, or nothing was done until the horse was sold to transfer the ownership of the horse from the nephew to the uncle or to the plaintiff. Only a proposal had been made, but until the day of the auction, until the horse was sold, there was nothing that could bind the nephew to sell the horse to his uncle. There was no acceptance of the offer. There was no other correspondence regarding the acceptance of the offer, stating that the nephew accepted to the terms stated by his uncle. Hence, the plaintiff's case to sue my client, the defendant, is null and void. It should be rejected from the court of law. Though later on, the nephew showed the acceptance of offer through his conduct, but his silence at the beginning cannot be considered to be as acceptance of offer. Therefore, it cannot be enforced for the defendant, my client, to apply for the conversion. Saying this, I would like to rest my case here. Thank you.